Gentleman's time has expired. Well, I'll go to the gentleman from Ohio, Mr. Davidson, for 5 minutes.
Chairman Gensler, recently a federal court called your rejection of a Bitcoin ETF, quote, arbitrary and capricious. In a subsequent interview, you dismissed the judge's opinion. Asked a follow-up question, if anything a judge says would change your mind, you responded, quote, well, no, not really. It seems that you don't really recognize the authority of the judicial branch. You seem to have a love for the Howey test, selectively applied as illustrated by Mr. Torres. But, in light of those reactions, what should people make about the Bitcoin ETF? How will the SEC revise its approach?
We have great respect for the courts. I personally have great respect for the courts. We're considering that. It's still an active consideration at the commission. And
so you haven't made up your mind? I got to tell you.
We're familiar with the case.
Yeah, I got to tell you that many market participants have reached out and are concerned that you will arbitrarily, perhaps also capriciously, pull recent filings ahead of others who've been working with the SEC for years to get an approval for a Bitcoin spot ETF. Will this resemble some sort of free pass for one favored company while others remain locked out? And I ask that because it seems that's happened before at the SEC.
Sir, I'm not sure if I'm following. I mean, we're still considering that court case and the application, as you say, to Bitcoin exchange-traded products.
Are you going to preserve people's place in line, or are you going to pull ahead a favored transaction or another on the consideration of a Bitcoin spot ETF? Are you going to preserve the place in the queue? Because timing matters. People have worked on this for years, and then you get a recent filing by somebody big in the market, and it seems like, oh, yeah, let me take your calls. How can I help? Meanwhile, you've given the stiff arm, as I've said, Hotel California-style regulations where you can check in with the SEC, but you can never leave. Never leave with clarity. And how about the legislative branch? Do you recognize the authority of Congress or the laws that we pass?
Yes, we comply with the laws that Congress passes every day.
Well, I've heard you say that about the courts and now Congress, which is encouraging, but I am inclined to judge your deeds more than your words. And, I'll pick up where one of my colleagues, Mr. Huizinga, left off with the Supreme Court decision in West Virginia versus the EPA. Are you familiar with that case?
Yes, sir, I'm familiar. It's an important case.
Glad to hear you say that. And it would be binding, correct?
It's the law of the land, sir.
That's right. And it introduces the major questions doctrine. And you told Mr. Barr that you received tons of feedback on your proposed ESG disclosure rules, feedback that should make clear that the proposal for ESG disclosure is a major question. And it should make clear that you don't have the legal authority to do that. So I'd ask you to knock it off. Cease and desist and work with this body to pass a law if you want to regulate something. Frankly, your time as chairman has highlighted two problems, a Gary Gensler problem and a structural flaw in the SEC. And as I told you in April, I proposed a solution called the SEC Stabilization Act. You're making the case for this bill easier every day you are acting as the chairman by doing rulemaking after rulemaking without any regard to the impact of these rules, or maybe that's the feature for you, I don't know. But it's having a massive impact on our markets. I mean, we have markets that truly are the envy of the world, and why would you disrupt them with processes that are driving capital out of our markets? Not because to avoid our laws, but to find some place where they can get clarity, where they can work with a regulator and get a decision and a path forward. So instead of selectively applied, you're not providing clarity with a rule that's evenly applied. You're intentionally shortening comment periods to limit feedback. And the courts have even called this arbitrary and capricious. You're pushing a woke political and social agenda, and I think abusing your role in the authority of the SEC as cover. So, I think fundamentally the SEC Stabilization Act would remove the role of chairman. It would preserve the current commissioners, but it would add a sixth commissioner. So there would be no more than 3 from any one political party. And so that would provide a path that would make the SEC do what you're avoiding. Frankly, you're front-running Congress, you're front-running the courts, you're front-running even the own administration, and no one has held you to account for that. I mean, I wish the Biden administration would say you're fired, but the list of folks they need to do that for is long. Congress hopefully will with the SEC Stabilization Act. I yield.
Gentleman's time's expired. We'll now recognize the